Our final case on the docket today is 24-1679 Constantine K. Yankopoulos versus Terry Yankopoulos, NKA Terry Turner. How much time would you like for recall?
5 minutes, please.
Okay,
Good morning.
you may proceed.
Good morning. May it please the court. My name is Jason Martorella, and I represent the appellants, Constantine Yankopoulos, who I'll refer to as the husband. This is an appeal of a judgment dismissing a petition to modify alimony. The parties petitioned for dissolution of their marriage in 2007, and in 2008, they reached a settlement agreement. Under the terms of the settlement agreement, the appellee, who I'll refer to as the wife, received the lion's share of the party's assets, including the marital home, and the husband was required to pay $7,000 per month in alimony. At the time, the husband was a practicing physician. He had his own medical practice. He served as a medical director, and
We know the facts, Counsel.
what's that?
We read the briefs. We know the facts.
Okay. Since the time of the agreement, he lost his medical license. There's the change in circumstances was that, but also, and the one that I want to focus on here today is the increase of income that the wife started earning between, again, the time 2008 and 2024. So-
Counsel, can I ask you a question about statute 61.14? As I read the statute, a substantial change in circumstances, assuming that criteria is met, it just opens the door for the trial court to then look at everything and then giving due consideration to that change, either increase, reduce, or keep the same, the alimony award. So my question is, even if it's true that the wife's need decreased by $5,000 or $6,000, does that necessarily mean the trial court must lower or decrease the alimony by the same amount? Or could the trial court say, well, based on the ability to pay now and the need now, 7,000 is still a good number, so I'm just going to leave it where it is?
I think the trial court had the discretion to do that, but that's not what the trial court actually did. The trial court found that there was no substantial change in circumstances, and that was based primarily, well, there was two things. In the oral pronouncement at trial, the court said that the wife still has a need for the alimony, irrespective of the adult disabled son's expenses. But in the judgment, she relied on the adult son's expenses in finding that there was no substantial change in circumstances. So that's the error in this case. Again, the wife, her income did go up significantly. It went from $0 to $5,319 per month, and that was based on her sale of the marital home for $2.2 million.
Was that an unexpected change in income?
There was no evidence that it was contemplated at the time.
So you got a final judgment that says the house will be sold, right? That's in the final judgment. It says the house is going to be sold. And they said at the final hearing, they expected the house to be sold. So the sale of the house was clearly contemplated. The only way I could see that you're saying the income wasn't contemplated is that it was contemplated she would sell the house, but not contemplated she would get any income from the proceeds. Is that the argument?
Yes, there was no discussion about what income that would yield and how it would be invested or what it would do. And also, I think there was a little bit of a question mark as to whether or not she was actually going to sell the house. At the time of the hearing, she hadn't even listened.
Well, it doesn't say it has to be fully certain. It says it has to be contemplated, right?
Right, that's the one.
Yeah.
Contemplated.
Yeah.
Yes.
So of course, I know there's some give in the case law between foreseeable and contemplated. Contemplated with a stricter version,
Right.
That you would want. At least the sale of the house, when the final judgment literally says when the house is sold, I think you've got a really uphill battle saying nobody contemplated the sale of the house.
I think our position is more on the income. There was no contemplation at the time that they entered into that.
All right, so you concede they contemplated the sale of the house. Just not the income she would receive from the proceeds.
Well, based on my view of the record and looking at the transcripts of, the discussion that was had at the time that the agreement was announced in open court, I think there was a big question mark still as to whether or not the house.
So counsel, when I ask a question, I need to give me an answer. I didn't say whether they knew it was certain. Okay. I said whether they contemplated it. They talk about it being sold. or use, they use the term when, final judgment refers to it being sold. All right, do you think it's an open question as to whether, not whether it was to her certain, but whether it was to, whether it was contemplated that she would sell the house?
I think it's fair to say that it was in contemplation that the
Oh.
property would eventually be sold, yes.
Okay, so you concede it was contemplated the property would be sold, correct?
Yes,
Okay, but you think the income she got from the proceeds was not contemplated?
absolutely, not contemplated. It wasn't discussed, and it was income that didn't start to accrue until, literally like.
Let me ask you this, if she had rented out the house instead of selling it, would the rental income have been not contemplated?
I don't think there was any evidence that there was a contemplation of income associated with the property at all.
I guess I'm saying, when you get a big piece of property and everybody knows with certainty you're gonna have the property, and at least contemplates the property will be sold, if not certain it's sold, they contemplate it will be sold. It just, is that not inextricable from the fact that you're gonna do something with the proceeds, you're gonna get a big pile of money? Like, how can you say you're gonna contemplate selling a house but not contemplate getting a bunch of money?
Well, I mean, there are different things that can be done with the money, obviously. I mean, there's not a requirement that she take the proceeds and then invest them. She could have purchased a new home. She did purchase a new home, but she purchased a much smaller home.
Let me ask you, if she had gotten that money and just blew it, she went to Vegas, had the best week of her life, spent all the money and never earned any income. So in that case, would she have no change in circumstances because she didn't have the income?
I believe, yes. I think there would be a much different, discussion.
So if she had blown the money, she would have kept her alimony. But because she did something productive with it, she loses the alimony.
Well, yeah, and it's for a reason, because she is actually earning an income. Like, for example, she took $240,000 from the proceeds of sale of house. She invested it in her son-in-law's pool company that went nowhere, and she just lost the money.
Yeah.
We're not saying that
But
money
you can
should.
see it under the way you're asking us to argue it, to decide it. She blows the money, puts it on racehorses, keeps her alimony, does something productive, loses the alimony, right?
I think that's because in one case she's.
That's, I'm not asking for because.
Yeah.
When I ask you a question, I need the thing that you respond with to be the answer to my question. Is that understood?
Yes, I agree
Okay.
with,
So-
with what you're
Do
saying.
you agree with how I'm characterizing it?
Yes.
Okay.
I think that the difference is, if I could explain why.
I'm okay with explanations. I just need the answer first.
Sure,
Go ahead.
sure. Okay, so yeah, I mean, there's a couple things about contemplation that I do want to focus on. Number one, this wasn't a developed factual issue below. The trial court did not deny or dismiss the petition to modify based on the fact that the sale of the home was contemplated. So that was something that was brought up in the answer brief. And I know there is the tipsy coachman doctrine, in which case the court can be affirmed based on matters that were not raised. But we're talking here, I think, about a factual issue, specifically contemplation, that there could have been additional evidence that would have been introduced on that issue to address it, to determine whether it was in fact within contemplation. The
Counsel,
other-
on that issue, can't we look at the judgment and the transcript of the agreement that, as it was announced in open court, and just say as a matter of law, they were at least thinking about selling the house? In other words, can't we, I understand, I think the distinction you're making between a tipsy coachman affirmance on, on some legal issue or something that's in the record versus tipsy coachman affirmance based on a finding that was never made by the trial court. But here, can't we simply look at the face of the record and see contemplation of sale of the house? It's right there. Now, understanding that leaves a question about what was contemplated as to the proceeds, and maybe that's where we need to focus. But there was at least contemplation of selling the house on the face of the record here, correct?
Yes, I think, I mean, to me, it's a little bit, it's not exactly a black and white issue. I think there's an area between, we're going to sell the house and we might sell the house. And this kind of is somewhere in that gray area, but I agree that the fair characterization is that they did contemplate that the house would be sold.
Does it make a difference in this case that the original alimony amount was based purely on agreement? In other words, there were no findings made in the original judgment as to ability to pay on the husband's side and need on the wife's side. They just said, we agree to this number. In the context of, and she's going to get a $3 million unencumbered house. it- Shouldn't that make a difference in terms of how we view what was contemplated based on the fact that it was all agreed to? This was a number they came up with, presumably after some deliberation and consideration, versus the trial court saying, here's the ability to pay, here's the need. Based on that, I get to this number, which seems like it would leave for the future determination if something about those numbers changed.
Right, well, I think the agreement was, as what was underlying the agreement as to alimony was an agreement as to need. The husband had the reported monthly expenses from the wife in her financial affidavit at that time. You know, they came to this agreement basically saying that with those monthly expenses, $7,000 a month is the need for alimony. And, you know, as those circumstances changed, you know, I think the way that the trial judge was kind of looking at this and sort of lost sight a little bit of the purpose of alimony, right? It's to maintain the standard of marriage that was established during, or the standard of living that was established during the marriage. And you're right, there was no evidence as to lifestyle or things that might support a finding as to the specific amount that was needed to maintain the lifestyle that was established during the marriage. Well, all we have is the agreement that $7,000 will do the trick. And as the circumstances then changed after that fact, well, now $7,000 is more than enough to do the trick. It goes beyond what would do the trick. And the reason why is because if you look at the monthly expenses between, again, 2008 and 2024, those didn't really change much. I mean, they did go up a little bit. And in our brief, we do, you know, say, well, if we pull out the expenses to the extent that they went up and that they were supported, there's still an additional $4,000 a month that she's now earning that she wasn't earning at the time that could be used to satisfy that agreed upon need of $7,000 per month.
Does the trial court have to assume that that the agreed amount of alimony at the time of the original final judgment accomplished that you know, that goal of keeping the wife at the level of income or the standard of living that she had enjoyed during the marriage? Or the fact, based on the fact that that was just an agreement, and now we have the trial court sort of opening everything up again, does the trial court have the discretion to say, yeah, her income's gone up $6,000, but I think that the number she needs to maintain that standard that she enjoyed when she was married is 13,000. So I'm going to keep the 7 in place because, you know, now is the first chance I've had to actually do a full accounting of what that standard should be. And I still think that number is correct.
Yeah, and I think, well, I mean, there's two things. Number one, are we going to honor, is the trial court honoring the agreement or not? And I don't think under those circumstances, she would be honoring the agreement because she's deciding, well, I'm going to basically take a fresh look at this and see, what is the need for alimony? So I don't think the trial court, I think it would have been erroneous, it was erroneous for the trial court to just simply you know, not uphold that agreement. But to the extent that there could have been a finding about the amount required to maintain the lifestyle during the marriage at that point in the proceeding, what there should have been was evidence on that. And that would have been the wife's burden to introduce that evidence as the party, not only the party seeking alimony, but also in the context of the petition to modify after the substantial change has been established with her increase in income, then the burden then switches over to the wife to establish that, hey, I still need this alimony. And so what does that require? That requires evidence of what was the lifestyle that the parties enjoyed during the marriage. And typically we see, you know, experts opining on that, reviewing expenses and, you know, lifestyle choices that were made during the marriage. And none of that was done here. The trial court looked solely at the wife's expenses as of the date of the trial and didn't there was no evidence for the court to consider as to the lifestyle that was established during the marriage. And so without that, even if the court could just disregard the agreement on the $7,000 being the need for alimony based on the expenses that were reported back in 2008, there was still insufficient evidence to support the judgment dismissing the petition to modify. And I'm a little bit close here, so I would And unless there are any further questions right now, reserve the rest of my time for rebuttal.
Good morning, Your Honor. May it please the court, my name is Allison Perry, and I, along with Linda Fried, represent the appellee, the former wife, Terry Turner. This case, of course, there has to be a substantial change in circumstances. It was not contemplated at the time of the final judgment in order to get a modification of an alimony award. Here, the court found there was not a substantial change in circumstances, and the court did have evidence as to what the standard of living was at the time of the agreement, because the former husband's financial affidavit was November 19th, 2008, and the agreement was reached the next day. So,
Wouldn't it have been the former wife's affidavit or standard of living that was relevant, though?
yes, and the former wife's financial affidavit, I believe it was like May of 2008.
So that was on the record from the prior
Yeah.
proceeding, right?
Yeah.
Does that make it evidence in the supplemental petition trial?
Well, the court, I believe the court took judicial notice of the entire file.
When you take judicial notice of a file, does that constitute judicial notice of the truth of the facts within documents in the file?
Well, these are notarized financial affidavit.
In other words, hearsay?
Yes,
Hearsay is not admissible?
hearsay is not admissible.
And so I guess back to the question I asked you then, if you take judicial notice of a court file, right? Does that constitute judicial notice of the truth of all facts stated within documents in the file?
No, but it was not contested that these were the expenses of the parties at the time they entered into the agreement.
Well, if something is never entered into evidence, do you need to contest it? You don't contest things that haven't been entered into evidence, do you?
Well, it was discussed and no one objected during the trial. So the sale of the house was clearly contemplated at the time of the final judgment. So the proceeds at the time of the final, of the agreement, the wife's living expenses totaled over $14,000, and that was not including the adult, disabled child expenses. So she agreed to get $7,000, which was much less, which is half as much as what she needed to maintain the marital standard of living. The husband's financial affidavit at the time in 2008 said his expenses were $19,000 and that he was earning negative income. So there is no substantial change in circumstances as to the former husband's income. He's actually making a lot more than he was making at the time. As far as the wife's income, it was contemplated that she would sell the house, and clearly she was planning on living off those proceeds because her standard of living was much higher than the $7,000 allotted in the for permanent alimony.
Counsel, I want to ask about the fact that this was the marital home. I'm wondering how we might look at that differently in terms of what was contemplated. If in a settlement agreement like we have here, the wife gets the marital home, and granted, it's a large asset. It's worth $3 million by their estimate back then. Is there not some expectation, even though maybe she'll sell it one day, that as long as she's living in that house, she's not making any money off of it. There's some expectation that she can stay there. But as soon as she sells that house, all bets are off. I mean, you have a lot of money that she didn't have access to before, and now she does. Even if it's the sale of the house was contemplated, is any income she makes off of that sale just off limits as being previously contemplated, or how do we decide, how much income from the sale of a big asset like that is contemplated and how much isn't?
Well, here it was contemplated that they'd sell the house. She stayed in the house, living off of her share of equitable distribution to support the house, because the expenses of that marital home were almost $7,000 just for the marital home expenses. So the income derived from what excess she invested, because she bought a house with proceeds, and then she took $800,000 and she put it in a CD. Now I think it was contemplated that she was going to get a substantial amount of money for the house. when she actually got $800,000 less than was contemplated.
How
She
much
only,
did she have to get before it's not contemplated? Like, obviously, if you're gonna sell the house, you assume there's gonna be some money involved, right?
oh, okay, let's
But-
say she's,
Like, for instance, what day was the house sold? What was the date of the sale?
it was 2017.
So let's say I mean, there's a market price for that house and she just drastically exceeds it, right? Let's say they find a gold deposit underneath, whatever, a celebrity moves in next door and everyone wants to buy the house. Like you could see a situation in which, yeah, they contemplated the house being sold, they contemplated some proceeds, but this is an unexpected amount of proceeds, right?
Absolutely. And in the final judgment, it said they expected the house was worth $3 million. It ended up only being worth 2.2. If it would have been the opposite and it was worth $5 million, then that extra $2 million absolutely would be a substantial change in circumstances that the court could take into consideration. Because no one thought she was gonna make an extra $2 million off that sale of the house. And that would just increase her needs that were contemplated at the time of the final judgment or the agreement. I think that there's an abuse of discretion standard, and that means that no reasonable person would have made this decision. And I don't see how that it can be reversed on the grounds that no reasonable person would say, hey, there hasn't been a substantial change in circumstances and there's still need established. So I ask that you affirm and also award her appellate attorney. Are there any
It's a
more questions?
conditional award you're seeking, right?
Yes, conditional award. Thank you.
Thank you.
Thank you. I just want to briefly address a couple of the statements that were made by the Applebee's counsel. She talked about the standard of living based on the affidavit. And I think there's this misconception that just because it is a monthly expense, it is establishing a need for alimony. Monthly expenses are not the same as the amounts needed to maintain the lifestyle that was established during the marriage. And what we're looking at, and what we should be looking at in context of an alimony determination, is what is the amount that's needed to establish the lifestyle that was, or to maintain the lifestyle that was established during the marriage. And the only thing that we have is these affidavits saying, basically, here it is. We had $16,000 of expenses before. We have expenses now that are a little bit more. And so our standard, the standard of living that was established during the marriage is essentially, the same as it was.
Can you address your opposing counsel's point that the house sold for less than was contemplated at the time of the final judgment?
Well, yeah, I mean, I think there was on the record during when they announced the agreement in open court, even my client at that point indicated that it's worth $3 million, but there's no buyer for it right now. So then that's one of the reasons why I think it's not as clear of a contemplation of a sale maybe than
But they got less than the 3 million, right?
they did.
So
Yeah,
they didn't exceed what the house was contemplated to sell for, right?
I think the husbands believed that the property was worth $3 million at the time of the judgment, and it sold for less than that.
Yeah. So it did not exceed what was the contemplated price.
Not with the husband's contemplation. I don't know that there's anywhere else in the record where.
So the sale of the house was contemplated, you've conceded. The amount of the proceeds was contemplated, you've conceded. So the only part here that could have been uncontemplated was that she would get some income from those proceeds, right?
Well, that certainly was not contemplated.
Well, I'm saying, but that's kind of that's the thing we have to find, because we don't get to the issue of, need and ability to pay if there wasn't a substantial and unexpected change in circumstances. And the only unexpected change you could get here, right, is not the house being sold, not the amount of the proceeds, but income from those proceeds. That's the only part that could be non-contemplated.
Well, I think there's also the Social Security payments that she started receiving. I mean,
But in terms of the house,
in terms of the house, yes, yes. But one thing that the appellee's counsel did also mention was that the expenses that she had associated with the house went down after she sold the house. And this is consistent with, if you compare the two affidavits, which again, they're not admissible, but we're looking at, the record
well,
with
so
every.
the current affidavits, that existed as of the time of supplemental petition, those were admitted, weren't they? They were admitted in the supplemental petition trial, weren't they?
I-
Because here's the thing we have in family law cases. affidavits are hearsay. They can't be admitted over objection. But in every single family law case, people admit the affidavits and nobody objects. So you have this document that is obviously inadmissible hearsay admitted as evidence in almost every single family law case. And that's what happened here. So I take your point about, the affidavits from the original trial, but the affidavits for the supplemental petition proceeding, those were admitted. You didn't object, right? And whether it's hearsay or not, it was admitted without objection. So that is evidence, right?
If it was admitted, but I guess, if it was, I'm assuming for the purposes of this appeal that both of the affidavits are accurate, to the extent, that they say what they say. I mean, I'm not disputing that, but if you just put in an affidavit, my monthly expenses are, X, Y, Z, that doesn't establish that, hey, those are.
But it does though, because that's testimony, like when it's admitted. Now, normally you can't admit that. It's hearsay, right? So if somebody objects and it doesn't come in, then I agree, an affidavit doesn't establish anything because it's not admitted evidence.
Right.
When you don't object and let it get admitted, now it does establish things.
Well, yeah, but I mean, I think what I'm referring to is that there was some discussion about the affidavit, right? It was, okay, walk us through it at trial. What are, you have this big increase in the adult son's expenses, right? It went from, being, I think, something like 1,500 or something at the time in 2008 to being over 3,000 at the time.
What you have is you're saying you have some conflicting testimony.
Well, there was other than that sort of self-serving statement in an affidavit, there was no evidence.
But is
supporting
there any rule that
portion.
says self-serving testimony is not admissible?
Well, no, but we're looking at, should be substantial competent evidence. to
Okay, so
support it.
is there any rule that says self-serving testimony is not substantial?
No.
competence?
Well,
So that's
no,
not
no,
fair.
no.
Yeah, okay,
It's
so you have testimony in the affidavit, which is admitted, you didn't object, you let it in. You have other testimony that you think muddles it. So sounds like you have two different pieces of testimony trial judges look at, right?
Well, I think, but I think that, when your question, you have a witness on the stand, they reported something in an affidavit in a conclusory fashion, and you start asking questions about that, and they can't substantiate the statement that's made in the affidavit. Now, I think there's, potentially now, depending on the circumstance, in this case, I'd say there was no substantial competent evidence supporting, at least a portion of the expenses that she reported in her 2024 affidavit. And that's our second point on appeal, is that there was $975 that were of monthly expenses that were just not supported by anything other than, her saying that she had those expenses.
Counsel, I want to ask you if it's possible to kind of separate out the different points you've made. For example, if we were to conclude that not only the sale of the house, but the income from those proceeds was contemplated and therefore off the table on a substantial change in circumstances analysis, could we still rule in your favor based on what's left? And on the other end of that, let's say we recognize the income as a substantial change in circumstances. Does the $975 really matter as a substantial change in circumstances?
Well, I mean, I think when you're looking at $7,000 a month, $975 is substantial, but it's more about, combining the different factors when you're looking at, substantial change in circumstances. That's the way that I look at it. But I think $975 $975 independently, based on a $7,000 a month alimony obligation is substantial. Certainly the court could deny or find that the income from the house was contemplated and still find that the Social Security benefits were not. And that is another piece, which is, I believe, it's in the brief, but it's $2,227 per month. And then I think the last issue that on appeal is this imputation of income of $850 based on the money that she could have made off of the $200,000 that was not invested after the property was sold. And those three issues, I mean, either one of them would reduce the need for alimony, again, based on the agreement. They're not, you can, whether you rule against us on one, you can rule for us in favor of us on the other, 100%. And that's for those reasons we would request that the trial court be reversed and that the case be remanded with instructions to basically reduce the amount of alimony in accordance with the court's conditions.
Thank you,
Thank you.
counsel. This court will be in recess.